morning, everybody. I'm Sophy Kwasny from the Council of Europe in Strasbourg. I'm very pleased to see all of you. It's the third day. We're already a bit all tired, but I know the discussion will be challenging, and we count on your commitment. So I'm very pleased to participate to this panel addressing intelligence services surveillance in the EU, fundamental rights, safeguards, and remedies. This panel is organized by the FRA, the European Union Fundamental Rights Agency, Mario there in particular on my right. Mario will present a report that has been prepared and published by FRA. The launch of this report was actually done in Strasbourg on the margin of the World Forum for Democracy, addressing the theme of surveillance and freedom. So fundamental rights, safeguards, remedies in the EU. So for the EU, it's 28 countries, but here at stake, it's actually more than 28 countries that are concerned, because in terms of human rights, safeguards and remedies, 47 countries have committed to the European Convention on Human Rights and are bound by its principles. There is abundant case law of the Court of Strasbourg in the field, dating back from 1978, class against Germany, and also recent latest cases. I will mention Szabo against Hungary and also Zakharov against Russia that condemn arbitrary, abusive surveillance practices due to inadequate safeguards provided by law, but also as to the implementation of the law. So it's a reaffirmation of the crucial role of the court that is carefully monitoring the surveillance legislation, but also how it's implemented, as I just mentioned. The work of the Council of Europe doesn't stop there with the work of the court. We have several other bodies dealing with surveillance. So I will mention the work of the Parliamentary Assembly of the Council of Europe. In particular, the report by Peter Omtzigt on mass surveillance that led to the adoption of a resolution on mass surveillance last year. We also have the work of our Venice Commission, that is constitutional law experts, that have published a report end of last year on democratic oversight. This also follows on previous work they had done in 2007, I think. And our Commissioner for Human Rights, Nils Muiznieks, published in spring last year an issue paper also on the topic of democratic and effective oversight of national security services. Those two reports I mentioned, the one from the Commissioner and from the Venice Commission, are available online if you want to have a look at it. But they basically reinforce the court case law in the field. I'm very pleased to be on the panel. I will introduce the panelists. So I will start by Mario, that organized the panel. Mario Oetheimer, Head of Sector for Information Society and Privacy and Data Protection at the FRA. He manages the project on national intelligence authorities and surveillance in the EU. Well, that's amongst other tasks. I also want to point out a publication that the FRA and the Council of Europe did together, a handbook on European data protection law. You can find copies of the book on the FRA booth, which is just in the village. Then to Mario's left for you, Carly Nyst. She's a human rights lawyer and independent consultant focusing on privacy, technology, and freedom of expression. She was previously legal director at Privacy International. That's actually when I had the chance to meet Carly in Geneva, and I want to thank her because I think she's been instrumental in having a UN special rapporteur in the field of privacy, and that's a great achievement. To my right, Wouter de Rede is the secretary of the Belgian Standing Intelligence Agencies Review Committee since 1993, so already a lot of experience and expertise in the field for a while, and also secretary of the Belgian Appeal Body for Security Clearances. Thorsten Wetzling, to my left, directs the privacy project at the SNV. I will not say it in German. You will have a chance to say it fully. That is a non-profit think tank based in Berlin. And you may also notice that we were supposed to have another panelist, Federica Resta, from the Italian Data Protection Authority, Il Garante, but she was unfortunately prevented from attending and being here. She managed last minute to organize a video statement for us. We really thank her for that. And we thank you in advance for your attention in watching our video. I also thank the organizers for their flexibility in technical terms and allowing for this video to be shown. So this is for the brief introduction to this session and our panelists, and I will give the floor to Carly now. Thank you.
Thank you, Sophie. And thank you, Mario, for organizing this panel of what I think is a really nice representation of different sectors that all have an interest and expertise in the field of intelligence and surveillance. I wanted to just contextualize conversation before we kicked off. Since the Snowden revelations began, we've seen a huge increase in and advancement in the question of transparency around intelligence services. I think that much is undeniable. You only have to look at the UK's draft investigatory powers bill to see just how far the UK itself has come in the past 3 years. When Snowden first made those controversial allegations, the UK government refused to confirm nor deny, and still does in many respects, many of the capabilities that Snowden asserted that the UK was deploying, including bulk interception, hacking, and others, which led a number of organisations, including Privacy International, to take the UK government to court. Now we have a draft piece of legislation which explains in great detail those very same powers and avows those powers in quite an astonishing level of frankness, in fact. And I think that in itself is a real achievement, to take things that were previously done in the shadows and really put them under the spotlight. On the other hand, there's something slightly, I want to say pernicious about this move towards greater transparency, in the sense that now we see governments avowing incredibly intrusive techniques and forms of surveillance and justifying them in public, rather than simply pretending they're not doing them. And I think that creates a new challenge, actually, from the perspective of human rights, as to, you know, if these things are done in the open and justified openly, how we are to bring them within a human rights framework. Interestingly, the situation has changed very rapidly. I know during Mario's work in preparing this excellent report, even in that phase of preparing the report, France adopted a new law which brought into the light for the first time the French intelligence powers, and really put French intelligence on a legal footing, some would argue, for the first time. Now, only in the last year, we've seen the UK, Netherlands, France, Switzerland all adopt or propose new surveillance laws which expand intelligence gathering, and particularly expand signals intelligence. We've seen Denmark and Finland also make murmurings of adopting similar laws. At the same time, we've seen the Schrems decision and this gap open up between US and EU surveillance standards, and a huge debate going on there, which is often misrepresented, I would say, and often overstated the reforms that have happened in the US as opposed to in the EU. We still have laws such as FISA and the Executive Order 12333 on the other side of the pond, which enable these types of broad intelligence gathering as well. And then we have the courts, which are going in the direction of strongest safeguards and standards. The recent 2 decisions of the European Court of Human Rights, Sakharov and Sabo, really propel the jurisprudence forward and quite strongly state a number of human rights standards applicable to intelligence agencies. So I think that we have an interesting gap opening up between state practice, which seems to be going often to larger and more expanded intelligence powers, and then human rights jurisprudence, which seems to be trying to restrict that same intelligence gathering. But perhaps we can kick off first by hearing from Mario on his experience in surveying the legal frameworks of all European Union countries and how that reflects these trends.
Thank you very much. Good morning, Ladies and gentlemen, I'd like also to thank the organizer for facilitating this debate, which I always found extremely, quite an important time in the year, the CPDP. And I'm extremely glad to be able to come back to present to you our report on intelligence service and fundamental rights safeguards. This report was triggered by, in fact, a very specific request by the European Parliament back when they adopted their resolution back in March 2014. And the European Parliament asked the FRA to start an in-depth study in this area. When we agreed to do it, I don't think we had the full understanding of what we were starting, and I think and I've said that several times already, that it's probably one of the most challenging projects I ever embarked, for several reasons that are linked in fact to our findings, and you will hopefully understand it. What we've done here is only the first step, in fact, of our project. This report maps the situation, a sort of snapshot of the EU 28 legal framework in the area of surveillance. We haven't tried to assess this legal framework. We're trying just to present them and put them in parallel to existing standards. Now, what we've seen after the Snowden revelations were, as Carly was mentioning, and also Sophy to a certain extent, reactions, condemnations, and in various quarters. And in fact, as recently as this week, 2 days ago, the Parliamentary Assembly of the Council of Europe issued a resolution on the fight against terrorism, stating again that member states should stop mass surveillance since it has proven to be inefficient, which I found was an interesting statement for the Parliamentary Assembly's, in the Parliamentary Assembly's resolution. However, on the other hand, you see that following the terrorist attack of last year, reactions aimed at legal reform, as Carly was mentioning, were clearly prompted by an enhancement of security measures. What was interesting to observe, including in France, was that while there was a lot of pressure to adopt the intelligence legislation, no doubt about that, there was also the space to a certain level to have a bit of a discussion on the so-called balance between freedom and security. And it really showed the difficulty to, in fact, achieve through law this balance. Well, at the FRA, we're clearly convinced that, in fact, putting it into a balance is maybe not the best approach, because fight against terrorism is in fact protecting fundamental rights, and I would see it more as two sides of the same coin, and certainly not as polar extremes. Now, what we've tried to do in this report was basically three different things. First, look at and present the legal framework governing intelligence services. Second, assess which independent and effective oversight system should be in place to properly protect fundamental rights. And third, what remedies can individuals have at their disposal in order precisely to protect their fundamental rights when violated. So let me briefly go through these 3 points. First, the existing framework. As a benchmark, we basically assessed and put together and summarized the existing human rights standards that have been adopted both at the UN and at the European Court of Human Rights. I think the advantage is that in both systems, you can see a convergence of view clearly on the way surveillance measures should be assessed. They should be clearly spelled in a law, follow a legitimate aim, and clearly be considered necessary and proportionate in the democratic society. What we noticed, however, and this was one of the, clearly the first challenge really for the analysis, is despite the existence of these human rights standards, and due to the lack of clear harmonizing competence, for example, at EU level, there is a huge diversity in the EU 28, which does not favor any proper analysis of the situation. We have indeed a patchwork of legislation and differences of approaches that are not facilitating the analysis. And clearly, there is not yet the solution that would work for everyone. Constitutional arrangements, history, trigger the setting up of certain legislation, and maybe during the discussion we can discuss about, for example, the way France has found solutions that are clearly entrenched into the French system. Now, the question of legislation, for example, is almost to a certain extent for traditional methods of surveillance solved in besides Cyprus and Portugal. All EU member states have a law on surveillance, but we're talking really only on targeted surveillance. When we're coming at the question of signal intelligence or large-scale surveillance, then it's a bit trickier, because we found that indeed 5 member states have detailed legislation in this field, and we studied them, analyzed them to see how they work, and these are France, Germany, the Netherlands, Sweden, and the UK. And that enabled us also within this group to find also the differences of approach and various powers of the services and powers of the oversight. Now, it doesn't mean that because we found only 5 member states that have detailed legislation, that there are only 5 member states that in fact carry out signal intelligence, as Kali was mentioning, but which indeed creates a problem when we start looking at whether or not member states have proper law in place that would detail the powers of the services. The other issue is clearly linked to public accountability through oversight bodies. And this again, we can look at the various systems and suggestion where and who are the players: parliament, expert bodies, data protection authorities. Again, great diversity, question of whether they have enough powers, independence, and expertise. These are issues that we've dealt with in the report, and notice that there are only maybe possible good practices that need to be assessed in a second phase that I will mention in a second. But yet again, not handmade solution, not ready-made solution, and certainly in the field of signal intelligence, while, for example, the Venice Commission hints to a useful solution to be found in Germany or Sweden, the models are not necessarily easily transposable. What counts, I believe, is that there should be a proper comprehensive oversight system that stick to the possibilities given to the services. So this is the key that should be found in the legislation. Now the court, the cases have been mentioned in Strasbourg, so has pushed a bit further its analysis. We still need to have a proper case on intelligence service to signal intelligence in order really to be able to assess the core principle. Since of lack of time, I'll jump the question of remedy. The biggest problem with the remedy is clearly linked to the information provided to the individual, and here all legislation of the EU member states have clear limitation to the notification requirements, which does not help to find solutions. Now to conclude, I just wanted to mention our next steps. What is clear is that we need, behind a assessment of the legislation, to assess how they are in fact implemented in practice, and this is what we're now doing through field research. We're aiming at interviewing key partners in 7 member states in order to really understand how safeguards are in place, how the control mechanisms are in place, and then only I hope to be able to come back next year with our findings of both legal and field research in order to be able to really suggest recommendation. Thank you.
Thank you, Mario. As Mario said, and I think the report does a great job of illustrating the differences in oversight regimes even across Europe are quite remarkable. So I think now we'll hear from Wouter, who can speak to the Belgium experience.
Thank you very much. Yes, I'd like to introduce, first of all, the committee I work for briefly. The Belgian Standing Intelligence Agencies Review Committee, it's a long word, is an independent review body created by law in '93, operational since 1993, and is responsible for reviewing the activities and functioning of the two Belgian intelligence services, the Civil Intelligence Service, called State Security, and its military counterpart, the General Intelligence and Security Service. The review relates to legitimacy, effectiveness, and coordination between services. The committee performs its review through investigations carried out on its own initiative or on demand of parliament, ministers, or even on behalf of a citizen, request of a citizen or civil servant. Since September 2010, Standing Committee has also been acting as a judicial body in the control of special intelligence methods used by both intelligence agencies. Some years before that, the committee was mandated to control also the interception by the military service of foreign communications. That's for the committee. I was asked to give you an illustration of the functioning of an oversight body confronted with the item of these days in reality after the Snowden revelations. So we were confronted with these revelations, and we were very soon charged, requested by the Parliament to investigate these matters. And thereupon the committee opened 3 investigations, in fact 4, because there was also a complaint from the chairman of the Dutch-speaking Bar Association in this matter. Our first investigation reported mainly on the discovery of the capacities of major powers for the large-scale interception and exploitation of data concerning people, organizations, and companies or institutions based in Belgium. And the second question, of course, was in what extent the Belgian services were aware of these capacities or even implicated in the use of these capacities. Or, on the other hand, did our services provide adequate protection in this regard? Finally, we had to make a judgment about the concept of friendly state in the world of intelligence service. In the first investigation, the Standing Committee wished to obtain an accurate as possible picture of the situation. We outsourced this at Dr. Anders Matthias Vermeulen, some of you might know here. And after that, we had several interviews with interesting people or organizations like Ms. Poitras and Mr. Applebaum. We also tried to make contact with NSA and so on, but that was a bit more difficult. And of course, we studied a lot the documents of the agencies to give us a better understanding of their position. I won't go further on describing the findings about the problem of the mass interception, because that's now common knowledge, I suppose. What is more interesting is what did our own agencies do. And in fact, it was quite simple. There are differences between reactions of the civil intelligence agency and the military. Certainly the civil service, and I'm simplifying, oversimplifying certainly their reactions, but they in fact didn't know, perhaps didn't want to know what was happening. That was a kind of strange attitude, because after the Echelon and the SWIFT affairs, we already asked them what their position was, and that didn't trigger them to follow up the situation afterwards. But we can say that state security was in no way implicated in the development or helping the other big agencies to the espionage programs. For the military, it's a bit different, because they had a more technical understanding of the possibilities of mass interception, because also they are clients of obtained SIGINT information. That is no secret. But themselves, it is not, excuse me, but they had a kind of technical knowledge and understanding, but they didn't know in what matters, what domains these interception facilities were used. And at a certain level, they were quite surprised when all the revelations came out that also economic, political espionage and so on was obtained, and that towards friendly states. But they didn't themselves were implicated in the using of these technologies, and didn't only get some information through it without knowing which systems were used, but they didn't have a knowledge on the specific software of the PRISM or other programs. After the revelations, we could see that the military intelligence agency had some problems, and it was the only agency, I think, who had a kind of protest towards these practices, and that was at least, I think, a positive sign. So all our investigations led to the final big conclusion that nothing much was done by our agencies in protection of our interests. So we concluded and made recommendations in our reports, recommendations to get our agencies and our government aware that when within one domain of intelligence, nations can be very good allies, and we need both each other, but in other domains, interests can be very different or even opposed. So lots of recommendations in that sense got its way and is getting its way even into legislation concerning the intelligence agencies. We also had finding an investigation on the legal matters, but all this is also known and no surprise. What can I say more? We have the third investigation, which is just finished this week. We'll have to give the privilege of the findings of this report to Parliament. It was about the implication between interceptions and economy and scientific protection of economic potential. And of course, there are links between those but in some weeks we hope we can publish our report to that.
Thank you very much, Wouter. Really fascinating to hear how much independence the committee clearly has, and the breadth of its investigations really contrast to some of other European countries and how they responded to the Snowden revelations. We're now going to see a quick video from Federica from the Italian DPA, which you may or may not know, in the aftermath of the Snowden revelations, one of the ways in which they responded was to sign a memorandum of understanding with the intelligence services. The DPA did, that is. And I hope she will touch on that element. So if the people who have the power wouldn't mind putting the video on.
The relationship between freedom and security is one of the most significant indicators of the resilience of a democracy. It's primarily because it's exposed more than any other to the perception of insecurity in the face of maximum randomness of death of terrorism today, which doesn't choose symbolic targets as in 1970s, but ordinary citizens. For its characteristic of difficult predictability, for the breadth of its range, and for the combination of symmetric and asymmetric capacity, terrorism, called of the ordinary time, requires today new strategies, and the main difficulty lies in combining defense effectiveness and respect for fundamental rights and liberties. If therefore the defense of democracy cannot and should not be suicide, it must not be even, however, a betrayal of its own idea and of the principle that distinguish it from its opponents. As Aaron Barak said, a democracy fights with a hand tied behind its back. Also because the massive surveillance could be not so effective. We could cite the example of the Patriot Act, which upheld a massive surveillance, flooding the intelligence services of information so numerous as so to be then, in fact, not very useful because unmanageable. The effectiveness of the defensive strategy assumes then it's addressing not to the general public, but to targets proved to be more dangerous as a result of investigation based primarily on the human factor. This is in particular the hope expressed by the Venice Commission in the report on strategic intelligence of April, in which it's outlined how it can become massive because it's based on systematic access to databases managed by algorithms, not really selective, and because it aims not at proving a specific offense, but at preventing future risk. To ensure the democratic sustainability of these measures, they must be selective and should be strengthened the system of checks and balances to protect fundamental rights and liberties. A system which consists first in mandatory legislative provisions to restrict the admissibility of such investigative tools to cases really necessary for the protection of fundamental interests, providing a minimum standard of concrete suspicion necessary to justify these measures, so evaluating the broadness of the selectors and, for example, the contact chain. It's also necessary to ensure the destruction not only of data illegally acquired, but also of those no longer needed, as required by the European Court of Human Rights in 206 in Weber versus Germany. It's also necessary to ensure the parliamentary, judicial, and technical by independent bodies such as data protection authorities oversight to prevent data over-collection which would make the strategic intelligence degenerate into massive surveillance. It's so very important the judgment of the Constitutional Court on the Portuguese law on intelligence powers, declared unconstitutional because it doesn't provide an inherent jurisdictional scrutiny for data retention, similar to one of the criminal trial. And very important is also the judgment by the European Court of Human Rights of the 11th of January concerning the incompatibility with the Convention on wiretapping carried out by the Hungarian intelligence services for an undefined time limit without judicial scrutiny and without any procedure that, after the end of security needs, could inform the person concerned of being subjected to control. But we can also remember between the best practices carried out by DPAs, the Memorandum of Understanding signed by our authority and by the Italian Information Security Department, which is the central branch of the intelligence system, on the 11th of November 2013. It's aimed at further strengthening the guarantees of the citizens by regulating certain informative procedures that are functional to the exercise of their respective powers. As the DPA President, Antonello Soro, clarified, the memorandum represents a positive response to the concerns raised by Datagate and answer capable to consolidate the supervisory activities of the DPA and allows a supervision of the archives used by the services. The prerogatives of the DPA are thus more in line with the peculiarities that characterize the powers of systematic access, making more systematic also the oversight carried out by DPA on the respect of citizens' right to data protection by the intelligence services. Right now, that Freedom Act approaches the use in this area, the European model, Europe must not deviate from those principles if it doesn't want to deny itself and its identity.
Okay, we're going to turn now, lastly, to Thorsten, who's going to speak to us about Germany, which is certainly one of the most fascinating countries when it comes to intelligence. It was obviously kind of ground zero after the Snowden revelations with Angela Merkel. Outrage, I suppose, could be characterized, much of it warranted, and then was one of the only country to institute a full government inquiry into the Snowden revelations. So looking forward to hearing from you.
Thank you, Carly. Thank you to Mario also for setting this up, and it's a pleasure to be here. I'd like to use my limited time to just say something about the outset and the context of what takes place in Germany at the moment, and then look at the more deficits that I found in a study that looked into the practical dynamics of oversight on SIGINT. And so if you look at Germany from the outset, you realize, of course, yes, it's, as Carly mentioned, is one of the few countries, I think the only country that has a systematic, full parliamentary review of the Snowden revelations as they pertain to the cooperation with Germany's intelligence with the Americans and the Five Eye consortium. And you also have Germany as a country that has been favorably reviewed by the Council of Europe report when it comes to its oversight regime. And you also know that Germany is one of I think the only instance that I know where a expert body has formally sued the government at the Constitutional Court over access to some of the material that they need to have access to for their work. So yes, there is a sentiment for privacy, and as Mario already says, something that you will no doubt discover when you turn to the second part of your report, it is very important to have very good laws, but the laws go only so far, and to explain the quality of oversight and the establishment of accountability. Hence, I would like to do two things: focus on the deficits and the limitations, and emphasize the importance of fundamental rights in the reform. So first thing with the NSA inquiry committee, they had three major revelations. So the first one was that, yes, Germany has a very good law, but it pertains maybe to 10%, that's a guess, but it has been published somewhere else, of the data collection that takes place by German intelligence. So 90% of what signals intelligence data collection means and is taking place is not under this remit. It lacks a clear legal mandate, is based instead on secret and unconvincing interpretation of the formal Intelligence Act. There's no judicial authorization for that kind of data collection, let alone any independent oversight. And yes, of course, then there are also no notifications and no effective remedy. So 90%, and I mean this, the collection of foreign data. The second revelation was that, yes, we know now that the cooperation between the German Exterior Intelligence Service, the BND, and the NSA in their use of selectors for finding the needle in the haystack, the Germans allowed the NSA to use selectors that did not, they were against the German interest and shouldn't have been used, and there was improper executive control over that. And the third revelation is that, yes, the BND and the NSA cooperated, and some of the selectors were not good, and they were against German interests, but the BND itself also, not just in its cooperation with the NSA, but also on its own, has used its digital power for matters that it shouldn't have, and they were German citizens that all of a sudden were found to be used as a selector, and then there was some espionage of allies, European allies. So these things are quite troublesome, and now the government and the parliament is looking into what we can do to rectify some of that. So my second point would be looking at the practical shortcomings of the existing regimes, because that would foreshadow some of the difficulties that the Fundamental Rights Agency will have when it comes to looking at the dynamics in the member states. So picture this oversight regime in Germany. We have three basic bodies that are tasked with intelligence oversight. When it comes to signals intelligence, it's the so-called G10 Commission that does. And it is made up of 4 individual members. Only one of them has to have the qualification to stand as a judge. And we don't know much about what the other criteria for the selection of these people are. They come once a month from the various parts in Germany to Berlin, and to talk about the legality and the necessity of all the federal intelligence measures when it comes to the 10% of what I have described, what the remit means. That by itself is a massive undertaking that takes time and technological savviness, and they don't have already on them their existing remit. They don't have the time for data handling investigations. When they get the warrant from the Interior Ministry, they have, on the day that they come to Berlin, they have to make up their mind whether they would like to allow this particular measure to be implemented. So there's no time for preparation. And also for others, like we've seen some progress in the US, there is no documentation or some sort of reporting obligation on the part of the G10 to say what their decisions were like and why did they come to that decision. What I find as a political scientist also most troublesome is that there is no dialogue between those 3 bodies that are tasked to do oversight. So they hardly ever have the chance to talk to each other. We have a parliamentary intelligence oversight panel. We have the G10 Commission, which is a quasi-judicial instrument that looks at the legality and the necessity. And then we have the Trust Committee, who decides on the budget. Now, these 3 panels, they don't necessarily learn from each other. They're not so much in dialogue. And yes. Then there's also the trouble with the existing. So bear in mind, when I'm talking about what the law stands for now, when we are not yet talking about how on earth they're going to find a solution for the 90% that they don't have on their remit yet. So even the existing regime can be abused for creative non-compliance. There was this case, it's called Operation Iconal. Some of you have known about it, where the German Telecom was quite uneasy about the peering of foreign traffic on German territory in Frankfurt, and they asked for a warrant, and then the executive came up with a warrant, but it was in a way done to dupe the G10 Commission by saying we want this authorization to to follow German communication abroad, where in fact the scope of this authorization was in magnitude was far beyond that. And the last point I want to make is, even you mentioned that, Mario, in your report, there's this 20% limit that says you should not, when you have foreign German communication, you shouldn't do more than 20% of that. But there's no criteria, and the 20% pertains to not to the amount of data, but to the capacity of the channel. So in fact, again, de facto, they do much more than 20%. So in the question and answer time, I think we have time to go into some of these questions in more detail, and I look forward to that. Thank you.
Thank you, Thorsten. So we have a good amount of time now to open up the floor to questions. So please kind of give me a wave if you have a question, and I can see Ian has one immediately. So, and then towards the back. So why don't we start with questions, and then if we run out, I've got a few myself. I don't think we have I'm not sure if we have a microphone. Oh, they're just coming from the back.
Thanks. Mario, I don't know if you've already planned in how you'll get over some of these difficulties that Thorsten was mentioning, and of course, particularly with the UK, the fact the UK has been so resistant to cooperating and talking about these issues at all because it wants to very firmly argue that the EU has absolutely no role in considering these issues because of the lack of national security competence. Even the fact that the director of GCHQ would not come and talk to the European Parliament, which I think was a real missed opportunity. I don't know if you have that trouble with other member states, whether you think you can get round some of the difficulties Thorsten mentioned.
Bart Perneel, University of Leuven. I think something else we learned from Snowden is that surveillance is no longer passive. There is a lot of hacking happening. And in fact, intelligence agencies are writing malware, which of course at some day will come back and hit our own countries. And my question is just, to what extent can you supervise writing and distribution of malware? Because this is something which is very hard to check and very hard to see how this is being spread. There is no reports about this.
Thank you. And I would add to that question, which I think is an excellent one for the panelists, to what extent should oversight agencies supervise or should we regulate the stockpiling of vulnerabilities or the disclosure of vulnerabilities to enable hacking, if that's something that people can speak to. Are there other questions from the audience at the moment? Just here.
Hi, I'm Friedrich Moser. I'm the filmmaker of the film A Good American that's going to be shown. My question is, how much transparency is there around the business aspects of state surveillance? And how can this be tackled?
You mean the role that businesses play in facilitating state surveillance?
Well, the economic interest by large parts of the industry to earn money on top of mass surveillance.
Well, shall we start with those three? Mario, do you want to?
Yes, thank you. I'll take Ian's question. Yes, you have a point there, but since we started, first of all, we were helped by the case law of the Luxembourg court, and this was tremendously helpful. The other aspect is the renewed interest by the European Parliament, which confirmed also last October its interest in our results. So yes, it's not a straightforward project, that's for sure. What I noticed, though, is since we've started, it was a very, very big support we've received from, for example, oversight bodies, which realized how useful it was to be able to discuss with us in order for us and help us in getting it right in this extremely complex field. So yes, we are not super welcomed, if you want, but there is not either an insurmountable resistance. And I think the way we produced our first report, which I think was phrased in objective terms in order to present an objective situation, at least as we understood it, will also help us in be able to enter into a further dialogue with the key partners. This said, I don't think we will want to go and see, for example, GCHQ directly, because I'm not sure it would be so helpful for us to discuss with an authorities that, in fact, we would not be able to receive much answers from. So, but you know, who knows? I'm always open to testing this. Thank you.
Can I ask an additional question? That is, if you're able to answer it, are you receiving any classified information or signing any kind of non-disclosure agreements or anything in the process, or is all the information you're receiving open information?
No, that's. Thank you for your question. I think what's very important, one of our first aspects in the beginning of the interview is to say that we are not really fundamentally interested in any secret information, because, for example, the memorandum of understanding that Federica mentioned is a secret document that is not accessible. We're not interested in accessing the document. What we are interested in is to understand how the authority, the oversight body, is basically implementing a legislation and therefore we don't want secret documents because we will not be able to use them in our publication. So this is really the starting point.
The mission of oversight in SIGINT and other base of is quite difficult because of the secrecy and all the vetting and screening which is needed to get into the inner circle. But for the moment, I may say, and I'm just talking about the Belgian situation, situation is not so dramatic in the way that, one, we have a kind of legal framework for the interceptions abroad and in Belgium. There is no really a problem of bulk, massive interception. But the main reason for that is the lack of capacities. So that's, in practice, the best protection for the moment. And that could change. And that's why we are always try to be awake when things might change in the legislation, to be aware that capacities shouldn't be extended without adequate empowerment of oversight. That's a bit our mantra.
Just following on from that, it's an interesting question about whether when technical capabilities expand or new technical capabilities are advanced, whether or not there should be a strong legislative grounding for each new technical capability. So in the UK, one of the arguments we've faced is that hacking can be authorized through a variety of legal provisions that were developed long before hacking. So the use of intrusive surveillance warrants to place bugs in people's houses is said by the government to be a sufficient legal authorization for the placing of malware on a computer by analogy. And these are arguments that are being made in legal proceedings at the moment. Is it the case in Belgium that there is a lot of disclosure about the technical capabilities? The way you just spoke about mass interception capabilities suggests that there's a more frank discussion going on there.
Well, when we talk about the homeland interception capacities and hacking and so on, and through entering IT systems and so on, our system is constructed that there are three kinds of methods that can be used by agencies. Normal methods that don't need any permission as such, because of open sources, running informants and so on. And then we have two degrees of specific methods or exceptional methods. And these methods are described in general as entering a house, a private house, or entering an information system. But how it is done is not prescribed in technical details. And I think it would be very difficult to do so because these techniques change constantly, and the evolution can be stopped.
Thank you, that's very useful. Thorsten.
Yeah, thank you. I would like to also address this question from this researcher in Louvain. Yesterday, Paul Nimitz mentioned the triads, the rule of law, the fundamental rights, and democracy. And to me, these things only gather their meaning when they're also upheld in practice. And I wanted to show, like, if you look at the statistics, and that should answer your question as well, you have in Germany, you have all together about 40 people, some of them part-time, who are tasked to review the entirety of all the intelligence of a community that has about 11,000 members. So if you think about additional tasks, what you mentioned, they're already struggling with the basic on what are the intelligence doing in terms of the policies that they enact, the oversight, and we haven't even discussed about the military, to what extent are they doing SIGINT, and there's so a lot of open questions. And now I would like to tie this to a remark to what Paul Nimitz made on the fundamental rights, because in Germany there's of course discussion about reform, and you can see two strands. The one strand is on the rule of law. There you can see progress. You can say, and I fully support that it needs to be more staff to parliamentary overseers. There needs to be more technical understanding of that. The other strand is the rule of law. Is the fundamental rights. And there you say, okay, this debate in Germany, there's a cease, because unlike, what are the costs for malfeasance when you have this done in a parliamentary oversight setting in Germany? There'll be reports, these take long times, maybe there's a constitutional case that will come, but that is like 2.5 years in the making. Compare that to the fundamental rights protection that the G10 can say. They have, and only them, and only those 4 people who come together once a month, have the power to say, stop this measure right now, because it is not legal and is not necessary. No one else has this power, and this is why in the reform discussions you hardly see much talk about the G10, which that's a different cup of tea.
On the G10, can I ask you, one of the big debates in kind of norm setting, standard setting around surveillance at the moment is the question of judicial authorization. And we've heard the lack of judicial authorization just this morning being held up as the major failing of European law in this sector. The FRA report helpfully sets out a table in which it says the 5 states that do bulk interception, what type of authorization do they have, and none of them have judicial, they all have either executive or expert authorization. The European Court, in its recent 2 decisions, has strongly emphasized, has gone further than ever before to say that judicial authorization is mandatory, and I would argue that they did say it is mandatory in SABO, but I think we probably need one more decision from them on that. In the German situation, where it is an expert body, I suppose, that authorizes it, would you say that judicial authorization would be a preferable introduction through the reform process, that you would like to see the G10 Commission either be staffed by more judges, or that it would sit firmly in the court system?
Yeah, thank you for that question. I think, yes, I'm a strong advocate of this idea that you would have to have ex-ante control of some of those measures. It doesn't mean that you may get the same rigor in practice, because then you would have so much more to do, but you need to have at least the possibility to have some before understanding of what. Let's say you are in this corporation of intelligence, and you know that there are thousands of selectors are being active at the moment, and they change regularly. You know, that's common practice. Now you can, if you do this only on an ex post mandate, you have no say when it comes to why are these particular selectors chosen, and you don't have the power to rectify this. And if you do this ex post, it might take a long time before you actually get your hands on that.
Although I would say Germany's still far ahead of some other countries in having oversight over selectors as well. Are there some other questions from the audience at the moment? Can we have a microphone here and here as well, please? I realise no one has answered your question on companies, and I'll throw it back to them. But I would say, from my own experience in the UK legislation, there's been a number of really kind of draconian provisions in UK law for a number of years, putting obligations on telecommunications providers and gag orders over the top of those obligations. The new draft law continues to impose a lot of obligations, including extraterritorial obligations. And we've seen the companies, and interestingly, lots of the US tech companies, big internet companies, speak out against those provisions in the committee review that's going on, which is an interesting development. I think, traditionally we've seen telecommunications companies be quite close to governments, but as with the kind of changes in technology, internet companies seem to be standing up and putting their foot down a little more. Can we get this question here?
Yeah, my question is to Mr. Wetzling. Because in Germany there were already a lot of cases, for instance, also with the state joy and horse that they wanted to imply, and there was the Constitutional Court of Germany said these are the rules within which you can do that, and the services didn't care about the rules. They violated them, and it took the CCT to take apart the software to see that that was the case. So I was wondering, did you already experience that there was a betterment, that even though there is some oversight and some rules to which they should be bound, that they actually apply those, or is there really need for something more dramatic shift to at least start that these oversights also have an impact?
Thank you.
Stephanie Perrin, University of Toronto, and I'd just like to link to a couple of other panel discussions that we've had here. The preceding discussion on averting cyber war, and the discussion that took place after the David Lyon book launch the other night, Privacy or Surveillance After Snowden, during which Duncan Campbell asked the question, well, should we just give up on Enlightenment values? A rather a drastic question, maybe, but I was wondering if you wanted to comment on this pressure between countries that have Enlightenment values with respect to the fundamental human rights and those who don't, particularly in the context of this arms race towards cyber war. I mean, I'm sure the security agencies have a view that they have to do what is required, and the pressure will be, I would say, stronger and stronger. We certainly see it in terms of judicial oversight in Canada, and increasing legislation to reduce that. So anyway, comments on that rather fundamental question. Not that we're ready to give up, but.
Thank you, Steph. Are there any other questions? Maybe? Okay. Sorry, was that did you want to ask a question? No? Okay, sorry. Thorsten first.
Sure. All right, thanks for the question. I think this brings me to the part that I didn't have the time in the 8 minutes to address, is the prominent reforms. There's no doubt that in Germany there will be increasements of the staff of parliamentary oversight in the near future. And there will be significant changes to the material issues that I addressed in the first part of my presentation. Question is how much. Now, what I'm going to say now is a bit of a speculation, because I haven't seen the draft. There is a draft, so this NSA inquiry committee takes place. They have the remit to also come up forward with recommendations, but this can go on until 2017, the whole legislative period. So before that, the government coalition parties in parliament, they have already done talks, and we invited some of it to our office in Berlin and had them speak out what their ideas were as to rectify some of those deficits. And there has been a story of one very talented journalist in Germany who apparently had access to a draft. It's the first draft, interestingly proposed, drafted by the Chancellery and not by Parliament, and now it's sent to Parliament, and maybe with a bit of luck we will start something that has taken place in England now as well on the IP bill. We would have a bill maybe in February or March, maybe already in February, and in the paper there were number of things, but with a caveat that we don't know if this actually will stand the test of time. But at the moment, the journalist who has access to this said there will be rules on extending the protection, data protection, that currently, so the 10% that only applies to German communication, that should be extended to making European Union member state communication, European Union institutions also under the same regime. Now that would be unprecedented, and I want to see it in print. I don't know if this, and they also, when it comes to this authorization procedure, there are some changes that are being discussed. So such measures, if there will be any collection of EU data, must be signed off by the president of the BND himself, or some of them very close to him, and then also going to the chancellery. But such measures must also have some ex-ante control in, and they haven't said yet whether this would be the G10 Commission or the control panel. And again, caveat, it might turn out completely different. But this is what we know. And it says here that the commission that will be tasked to have this extended remit, they have to make that decision before the planned infringement measure takes place. And there are lots of more difficulties, like whether this pertains, then there's the last really important issue is, when they make this extension, does that relate to the peering of foreign internet cables that takes place in Germany? So here you would have the German service doing something on German territory with regard to foreign data. They want to regulate, have some legal norm for that. The question is, what about the interception of foreign data that may take place outside of Germany? Now that is something the one party wants to address this, the other one hasn't said anything about it, and we can brace ourselves for some interesting discussions.
Thanks, Wouter. Oh, sorry, Thorsten. Wouter, can we turn to you, and maybe you could address Steph's question around whether we're in a cyber arms race?
Yes, I'd like to. I do think it's quite obvious that the recent events and the terror threat give extra pressure to the governments and to the agencies to use every possible way, technical or not, to get the information in due time. There are also pressures, I think, quite logically, that several states are seeking more and more for allies in a broader network of agencies working together. As such, it's not that it's not a bad thing as such, I would say. And there are also evolutions. For example, because of the Snowden revelations, there is more encryption. So there is difficulties, technical difficulties to get access to content. So agencies are now more interested than before in metadata. All this is on very short time evolutions that we can see. We also see that the more international cooperation there is, as such, it's not a bad thing, but that needs, I think, also a better cooperation between oversight of the different nations to restore the balance.
It's an interesting point in the context of yesterday's decision in Canada, which has resulted in the suspension of sharing of metadata amongst Five Eyes countries. I think that as you said, it's increasingly the most valuable tool for intelligence agencies. Unless there are no more questions, oh yeah, there's one at the front here. Do you mind coming up with a microphone? And if anyone else has a question, please do raise your hand.
Hi, Brendan Van Elsen, University of Leuven. My question kind of builds on what was coming up, this increased collaboration among surveillance or intelligence agencies. To what extent do the oversight bodies, so I guess my question goes mainly to Mr. Derider and Mr. Wetzling, when they decide or are determining whether or not a particular measure is authorized, to what extent do they actually assess the scope of the surveillance mechanism in place in other states, right? You might come to a conclusion that, you know, looking for this particular individual or targeting this particular individual makes sense or is justified in a particular case, but that the manner in which this data was collected by the other surveillance agencies was perhaps disproportionate or excessive due to its scale. And is that something, I mean, do you indirectly kind of do a peer review that way as to the mechanisms in place in other countries?
And a direct follow-up on that, thinking about the European Court of Human Rights case, Essen-Marper versus the UK, where they used precisely that kind of reasoning to say the UK's DNA database was way bigger than the rest of the Council of Europe states, and therefore that was one reason it might be considered disproportionate, whether, again, that might happen in this sector.
Quick answer to a big question.
Well, the international and growing international dimension is happening on all levels. First of all, also by the bad guys, we must say. So it's understandable that we seek, or the agencies seek, more cooperation between agencies of the different countries. But we also think as oversight bodies, we have to cooperate better and better with our counterparts in the other countries. One of the difficulties is that there is a disparity in bodies and structures and missions and powers of these oversighters in other countries. But for example, we can give a good practice. We have very frequent contacts with our Dutch counterparts, and we can exchange working methods, methodology, themes, items of interest, and we share, of course, our publications and so on, and we have also informal, but there is a clear territory of classified information that we can share for the moment.
Yeah, I think we reached the stage of closing the panel, so thank you very much for your attention. Thank you to the panelists. I think, Mario, we look forward to the second phase of the project, so maybe see you next year in CPDP for the presentation of the outcome. I don't know what's your time frame, but we'll be there with pleasure. We can only remain attentive to the developments. There are pending cases in Strasbourg against the UK in particular that will be very important to follow. And as Stephanie said, we don't give up. So thank you very much. Please join me in congratulating the panel. Thank you.